let's start the session today. So, welcome to the webinar. Thank you for joining in on a Saturday evening. We'll be discussing the issues of delayed payments to MSMEs, what are the challenges and the solutions of those challenges. So, moving forward, what would be the agendas for the discussion in the webinar today? We'll discuss the definition of MSMEs under Micro, Small and Medium Enterprises Development Act of 2006, which is called MSMED Act. The qualifying conditions to apply for registration under MSMED Act, the qualifying conditions for your enterprise to be a micro enterprise, small enterprise, or a medium enterprise. So, what are the qualifying conditions for each one of those classification which has been made in the enterprises categories? So, we'll be discussing the qualifying conditions for registration under the MSMED Act, the challenges and issues pertaining to delayed, defaulted, stuck payments from buyers. So, what are the challenges and issues which pertains to these issues, such as delayed, defaulted, and stuck payments from buyers? So, we'll discuss those challenges and issues. After that, we'll discuss the important provisions under the Micro, Small, Medium Enterprises Development Act for the benefit of MSMEs, the solution and way forward to resolve the issues of delayed payments when the issues have already arisen, the issues of delayed payments, how do we resolve it, and what are the way forwards to resolve such issues of delayed payments. We'll discuss those issues, and there are preventive measures also. So we'll discuss these in two aspects, right? So the first aspect would obviously be the preventive measures, that what are the preventive measures that you can adopt so as to you can reduce significantly the issues of delayed payments in your businesses. So we'll discuss those preventive measures too. The resolution mechanism, as I stated already, that the first aspect of us dealing with the delayed payments would be the preventive measures. But then when the issues have already arisen, then the solutions and the way forward, as I stated, that we'll be discussing solutions and way forward to resolve such issues if those issues have already arisen. Then we'll discuss various resolution mechanisms, which includes alternate dispute resolutions, and which alternate dispute resolutions. And in alternate dispute resolutions, there is this online dispute resolution, which is a new way of resolving disputes through online way. So we'll discuss that briefly. We'll touch upon that briefly. uh, After moving forward, we'll discuss the litigation part of it, that the various laws under which you can approach the court for recovering your money if the jurisdiction of MSMED Act is not been made out. So we'll discuss those, the litigation aspect of it, that how do we approach courts under various laws to recover our payment. And lastly, we'll give you some tips and suggestions which you can adopt in your internal business operations or external business operations, which would definitely streamline your businesses and would help it to effectively go through to have a seamless operation of your businesses. So that the issues such as this, like the delayed payment issues, the defaulted payment issues, and the stuck payment issues, are not are reduced significantly, or at least you're aware that these issues might get converted into such issues of delayed payment and default payment at the very advent of it. So we'll discuss those. So let's start the agendas. We'll discuss all of these aspects one by one, and we'll briefly touch upon this because we have had very elaborative webinars in the past, and the Udyamita helplines every time uploads our webinar on YouTube platform. So you can just go to Udyamita helpline channel, and you can tune into any of our webinars. So along with me, there are other experts also who have been invited to speak on the issues of delayed payments and ancillary and related issues. So I would strongly advise you to go and tune into those videos and get information, whatever you can gather from all those videos, because taking a holistic view of of the webinars which we have been doing from the past, and which we are currently doing, would give you a holistic view of how these things should go, and how you can effectively manage your businesses, how you can take help from these webinars. So yes, so let's start. So the first thing is, what are enterprises? So the enterprises are categorized into two categories. It's bifurcated in MSMED Act. So the first category includes manufacturers and service providers. So what are enterprises? Any enterprises, the definition under Micro, Small and Medium Enterprises Development Act, as far as the definition of enterprises goes, is very wide. Is very wide in a sense that it includes manufacturers and service providers both in one category. So if you are manufacturing any product, then the first category takes care of you being a manufacturer. You are included in the first category. That your enterprise would be governed under the would be eligible enough to get a registration under the MSMED Act in the first category, because it includes manufacturers of various goods. And then it's service providers both in one category. So manufacturers and service providers are taken together, and they are put into one category. There's this second category which includes traders of good. Now, what are traders of good? Traders of goods generally do not manufacture it, or they do not indulge in providing services also, right? So what does traders of goods do? So traders of goods acquire some manufactured products from some manufacturer. Uh, let's say you have acquired some TMT TMT bars from a company, from a manufacturer, and then what you did is, uh, you factored a profit and you sold it in retail further, after taking into a factor a profit for yourself. So that is traders, because you're not manufacturing it directly, you're just acquiring it from a manufacturer, you're white labeling it. You might say that you're white labeling it, you're labeling it in your name, and then you are factoring a profit for yourself, and then you are retailing it. Now, as I say that you are white labeling it, or you're labeling it in your own name, that is not even necessary. If you're acquiring a TMT bar from some, let's say, a manufacturer in Delhi, and after factoring a profit for yourself, you're retailing it out in Delhi, in Patna, let's say, or Mumbai, let's say, then you're neither manufacturing it, or nor you're indulged in any service providing, right? So you're just factoring a profit for yourself, and you're bridging the gap between the manufacturer and the client, because the client is based in Mumbai, right? And the manufacturer is based in Delhi. So what you did is you bridged the gap between the client and the manufacturer, and for that you have factored a profit for yourself. So in a way, you're not a manufacturer, you're not a service provider, but that's what a trader of goods are. So they acquire goods from some other manufacturer, and after factoring a profit for themselves, they retail it out to other retailers. So the second category includes trader of goods. Now, the trader of goods, however, the MSMED Act includes trader of goods, but it does not give them all the benefit that it gives to the first category enterprises, which includes manufacturers and service providers. Like this, manufacturers and service providers are eligible to avail all the benefits that are given under the MSMED Act, right? So they can go before MSAFC for filing of reference cases, for filing of cases where the payments are stuck, delayed, or defaulted. But when we talk about traders, when we take into consideration, take into account the second category, which includes trader of goods, then the same benefits are not extended to the second category of enterprises, which is the trader of goods. Now, the only benefit which they have extended are, I guess, the sectoral benefit of credit availment. So that's the specific thing they have extended it to traders. However, all the other benefits which are otherwise available to manufacturers or service providers, they are not available to traders of goods, because the office order with which the trader of goods were included, which is there in the uh, heading, which is amended by the notification dated 26/6/2020. So if you'd read the notifications, you'd read that notification in detail. So you'd see that the extension of the benefit is only restricted to one particular sector, which is, I guess, I'm not very sure. I'll have to refer the notification, and I would strongly suggest that you refer the notification to the office notification, which is issued by the Ministry of MSME, that they included the traders in the definition, but they have not extended all the benefits to traders. The only benefit they have extended are the credit system, the facilitation of credit system. So I guess that the traders can get the benefit of availing credit on lower interest rates from various financial institutions, non-banking financial companies. But then they cannot go to resolve their disputes in section 18, under which you can file a reference application for defaulted payments, because trader of goods are not given all the benefits which is there for manufacturers and service providers for the first category enterprises. So I hope I'm clear till now. Okay. So two parameters basis which classification is made between MSMEs are investment made in the enterprises, plants, machinery and equipments, and also the turnover immediate preceding financial year generated by the MSMEs. The parameters lay out the quantum of investment and turnover required for registration as MSMEs under MSMED Act. So as I stated, the enterprises are bifurcated in first category and second category. The first category includes manufacturers and service providers. The second category includes trader of goods. Now, there is further classification. There is one more classification of enterprises which is being made in MSME, and that is based on two parameters. The first parameter is the investment which those enterprises have made in their plant, machinery, and equipments. So for computing the investment made in businesses, the investment made in plants, machinery, and equipments can be taken into account. So that is why it is written plants, machinery, and equipments. So there are two parameters. What is the tune of the investment made in the enterprises, and the turnover generated by those enterprises. So basis on these two parameters, there are three classifications. First is micro enterprise, the second is medium enterprise, and the third is small enterprise. Right? The parameters lay out the quantum of investment and turnover required for registration as MSMEs under MSMED Act. So as I stated, these parameters lay out the quantum of investment. So it states that this much of quantum of investment if you have made, and if your turnover generated is till the tune of this quantum. So the quantum is given. I'll come to that. Then there are classification given on those quantum, right? So the lowest quantum falls under the micro category. The moderate quantum, which is somewhere in the middle of micro and the highest, which is medium, falls the small category. And lastly, the highest category is for the medium enterprises. So coming to the quantum which is given, yeah. The table laying out the quantum of investment and turnover for enterprise to be registered as any of the micro, small, or medium enterprises under MSMED Act. So this table lays out what are the quantum which the Act states, which the Act provides for the company to get themselves registered as any of these enterprises, be it micro, small, or medium. So the note says both parameters, investment and turnover, has to be met for an enterprise to qualify as either micro, small, or medium enterprises basis the parameters laid out here in below. So it states that both the parameters had to be met, and it cannot be so that you have met one of these parameters and the other parameters is not met, but you can claim the registrations. So both the parameters have to be simultaneously meted out for you to get yourself registered under any of each of these categories, be it micro, small, or medium, right? So the investment, as I stated, includes in its expression all tangible assets, except land, building, furniture, and fittings. However, the turnover shall be computed on the preceding year's ITR filing. So as I stated, key the quantum is fixed in investment criteria and the turnover criteria, right? So we'll have to find out what does investment includes. So what expenses would come under the investment, which you can say that I made in my plant or enterprises, right? So investment would include, as I stated in the previous slides, in the previous slide, is plants, investment made in the plant, machinery, and the equipments that you have had in the enterprise, right? But it does not includes, as I stated, all tangible, sorry, not all tangible assets, but except land, building, furniture, and fittings, right? So all of these are not included in the investment criteria. So you cannot include the land's price in your investment quantum, nor you can include the expenses to erect a building, let's say, or to get your furnitures and fittings in the enterprises, right? So all of these are excluded from quantifying the investment made in any enterprises, right? And the turnover would be computed basis on the preceding year's ITR filing. So whatever your preceding year's income tax return would be taken into account as a turnover for your enterprises, right? So that is how we compute the quantum which is provided by in the act, which is provided for in the MSMED Act, right? So the micro enterprises investment should be less than or equal to 1 crores. So any investment which is lesser than 1 crore or is till the tune of 1 crore, if investment made in that enterprises is till this quantum, then it is to be registrable in micro enterprises. Also, the turnover would be taken into simultaneous consideration, right? Because both of these quantum has to be met simultaneously. So your investment must be less than 1 crore or equal to 1 crore. Simultaneously, your turnover generated annually should also be less than 5 crores or equal to 5 crores. Now, let's say if your investment or turnover exceeds from either 1 crore or 5 crore. So, because as I stated, both the quantum has to be met. So, if any of these quantums are not meeting, or if you have exceeded any of these quantums separately, let's say you have exceeded the investment criteria by 1 crore, then even if you have not exceeded the turnover criteria, which is of 5 crore, then also you'll have to get yourself upgraded into small enterprises because your investment quantum has increased, exceeded from 1 crore, right? So going forth, the small enterprises, the investment made should be 1 crore till 10 crore, right? Because till 1 crore it is of micro enterprises, the registration would go in under the micro category. So if it exceeds above 1 crore, beyond 1 crore, then and the limit for small enterprises investment made in enterprises, the quantum for investment in made in enterprises is 10 crores. So for small enterprises, for getting registrations under small enterprises, the investment quantification is given as 10 crores of rupees, and the turnover generated annually is given till 50 crores of rupees. So if your investment is somewhere between 1 crore to 10 crores, and your turnover generated annually is somewhere between 5 crores to 50 crores, then your registrability is under the small enterprises category, right? Because you have exceeded the quantum for micro enterprises. Now, the same goes for medium enterprises. If you have exceeded the investment from 10 crores and you have exceeded the or you have exceeded a turnover generated annually from 50 crores or beyond 50 crores, then your registration would have to be upgraded into medium enterprises. The medium enterprises quantification, the limit of quantification is your investment made in enterprises should not exceed 100 crores of rupees, or your turnover generated annually should not exceed 250 crores of rupees. If it exceeds 100 crores or 250 crores of rupees, then the MSMED Act would cease to have applicability upon your enterprises because you have exceeded all the criteria that there is in MSMED Act, because your enterprises is beyond the applicability and operations of MSMED Act. Now, the quantum which is there of 250 crores or let's say 100 crores does not apply to you. So your registration wouldn't be there because you have upgraded and your enterprises has gone out of the beyonds of MSMED Act, right? So I hope that you have understood this. Uh, let's move to the next slide. So, reasons for delayed payments and its consequential effects on MSMEs. So, I've said this time and again, and I'm saying this again that there are few issues because of which generally these issues arises in the first place. The issues of delayed payments. So, if you're considering all of these tips and suggestions carefully and you're adopting it effectively, then I believe that following these tips and suggestions that will discuss in a short while would significantly reduce the possibilities of issues arising in the first place, issues relating to delayed payment, defaulted payment, or stuck payment, right? So we'll discuss those reasons for the delayed payments and also the consequential effects that it has or that it have on MSMEs, right? So the first is not documenting or recording of the transactions, delivery of goods, materials, or performances of services without any work purchase orders, not recording terms and conditions in an agreement, not adapt with quick turnarounds for reserving rights, etc. So this is the first and foremost reason, which is also a very major reason, which is also a very major reason, uh, which is whenever you are entering into any transaction with, let's say, any corporate body or any body, be it a trust, be it a society, be it a government body, or a government company, a private limited company, a LLP, or a private firm, or a partnership firm. So it doesn't matter with whom you are entering into the transaction with, but what matters is there a document which reflects the terms and conditions of the transactions which you entered with that party? If there is, then that document becomes very helpful in securing your rights. If it gets into let's say, if it gets disputed, or if you have to litigate for realizing your payments, then these documents, which forms the basis of the transaction, the terms and conditions, the obligations of the parties, these documents become the guiding document for any arbitrator, any adjudicator, or let's say any judge to refer to and to determine that what was the obligations, what was the nature of the transactions between the parties, right? So the documenting or recording of the transactions, be as it may, the transactions relating to, let's say, providing any services, the transactions relating to manufacturing goods for any party, right? Or let's say manpower agreement, where you had to give manpower to certain construction activities, and all of these transactions. When I say transactions, I take into account all of the transactions, right? Be it service providing agreements, be it any sort of agreement, right? So if it is documented or it's recorded, the transactions are recorded, then a lot of things becomes easier for you, right? Because how the goods were agreed to be delivered, what was the primary duty of you in that agreement, or of the opposite party in that transactions were, can be ascertained can be ascertained by referring to these documents, right? And what was the delivery schedule of the goods, how the delivery was to be made. All of these things can be anticipated and can be written down in a contract or an agreement before you enter into a transaction, right? Before you enter into a transaction, you can make out an agreement or a contract to govern that transaction between the parties, right? So it would have the delivery schedule, the materials for performance of services, uh, so it would have a lot of other things, host of other things, right? Such as the terms and conditions of the parties, how the goods were to be provided, what was the delivery schedule, what was the term of the contract. So all of these issues are already there in the contract, right? So if you reduce it in the writing, the terms and conditions upon which you want to govern the transaction, the terms and conditions upon which the transactions you want, upon which uh, the transactions you want to enter into. So if it is reduced into writing, then that is the primary evidence. Right now you cannot go into and produce the oral evidence, because there is a document, a written document to that regard. So the primary evidence would be that document itself, and your statements to that regard would not be taken into consideration if it has certain exceptions, which I would not go into, because it is an evidence act, and it would be technical uh, class of evidence act. So I am saying that a governing agreement for any transaction is very much important, because it anticipates all the possibilities of these issues getting if these issues getting into the picture, right? So all of these things, if are documented or recorded, then the parties go through the terms and conditions which are recorded thereunder, right? Because they know that if they are not complying with the terms and conditions thereunder the agreement, then they might be under the breach of such contract or an agreement, right? So that is the first reason, not documenting or recording the transactions, because the transaction involves, sometimes the transaction involves, I've seen companies and MSMEs entering into huge transactions involving crores of rupees, but there is no let's say work order or purchase order, or even a contract basis on which you have entered into that transaction. So it becomes really difficult for parties to prove terms and conditions, to prove certain things, if they do not have any document or recording of the transaction, right? Because then you can only prove it through the conduct and other ancillary things, right? Because there is no reduced in writing document which you can refer conveniently, and you can ascertain that these were the terms and conditions agreed upon the parties, right? So that is the underlying principle, that if you anytime enter into a transaction with any party, be it a government body or a corporate, be it a huge corporate, you have to have an agreement in place, right? So that is the first thing you have to check, that if you're entering into any transactions, be sure, make it a point to have an agreement in place, right, before entering into that transaction. So the next point is the extended credit period, continuing with the transactions even after delayed payment issues with the hope of retaining buyer clients. So now, this is a very practical issue, and this I do not have a lot to say in this, because it's more of a commercial wisdom, and you have to decide as a businesses that if you are extending this credit period to some companies or not, if it is ultimately a good business decision for your business or enterprises or not. So I have seen that whenever there is let's say a running account transaction between two parties, where you had to deliver some goods, or to perform some services for a period of time, which uh, which goes from around, let's say, 6 months to 1 year. So you had to manufacture goods over a period of 1 year, or let's say 6 months, or you had to perform services over a period of 6 months or a 1 year. I've seen practical cases where, right from, let's say, first or second month, you received the payment on a timely manner for the first month, but you're not received the payment for the second month, and it's a 6 months contract, let's say, but you have not received the payment for second month. Now I've seen a lot of enterprises that they continue with their services or the manufacturing of goods, right? They continue delivering those goods, or performing those services even when they are not getting the payments for it. So let's say if they have not gotten any payment for the second month, then what they do is they continue performing the services for the third month, 4 month, fifth month, and lastly the 6 months also. So you, from your part of obligations for, or from your performances, have performed the contract in full, right? But the other party is not performing, or not complying with the terms and conditions of the contract. Now it has to be your commercial wisdom, because I would suggest to all of the enterprises to not go with the extended credit period for a long time, because in the MSMED Act, the MSMED Act gives an credit period of 45 days. So the MSMED Act says that the amount fell dues, any invoice, if you have raised an invoice on the opposite party, the buyer of the goods, or the buyer of the services, to whom you are performing, to whom you are giving your services, right? So the extended credit period, which is extended under the MSMED Act, is till only 45 days. It says that whenever you have raised the invoice, from that day till the 45th day, you cannot ask for any interest component, right, for those 45 days. But once that 45 days are over, beyond 45 days, as you all know, that MSMED Act gives you an interest, gives you a right to demand interest from the buyer three times the interest rate notified by the RBI, which comes at around 18.5% of interest, which is compounded on a monthly basis, which is a huge penal interest, if you'd ask me, right? Because if even if you compute it mathematically, even a small principal amount, if compounded annually, would multiply in multifolds, right? So these are the precautions that the legislature has introduced into the MSMED Act in order to ensure timely payments to the MSMEs, right? So these are the safeguards which the legislature has introduced, which states that if any delayed payment issues are there, and they had to make payments after you have raised the invoice, and the 45 days credit period is also over, then from that 46th day onwards, you can charge the client three times the interest rate notified by the RBI on your principal amount, which has to be compounded on a monthly basis, right? So that is a safeguard. So if it is there for 45 days, the act only gives it for 45 days. I see no reason for you to extending it more than beyond 45 days, right? So it makes no sense, because as per act, you would, from the 46th day, would be eligible to ask for the three times interest. So you wouldn't by yourself restrict yourself for another 15 days. Let's say you have extended the credit period for 60 days. However, the act gives it only for 45 days, then there is no sense for you to increasing those credit period for more than 15 days, for more 15 days, right? Because you have agreed for 60 days. So I believe that the extended credit period should not go beyond 45 days, because it is there in the act also that the 45 days should be given, and after 45 days, from 46th day onwards, the interest component is uh, the other party is liable to pay the interest component, right? So the extended credit period has to be carefully extended to certain businesses which you believe that their the operations, the businesses with those businesses who are not making timely payments to you are more valuable than getting those timely payments, right? So as I stated, it's commercial wisdom, right? So I know a lot of companies who are not making timely payments, but MSMEs continue delivering them goods and services in the apprehension, in the hope that they will make the payment in a one tranche, right? After I've completed the contract, and it happens sometimes that the companies do not default on your payment terms, and they actually pay, but you never know, right? So I had to just say that be aware of the extended credit period, keep it in check, and I do not see any reason for it to be extended more than 45 days, because the act restricts it to 45 days, right? So uh, coming to the third point, challenges faced due to competition in the relevant market. Industry specific challenges such as disrupted availability of raw materials, etc., competitive rates with minimal margins of profit. As I stated, all of these are commercial wisdoms, right? So all of these, as a business's owner, or someone who's managing a businesses, or someone who is on a managerial position in a business, had to have to or had to take this into consideration, right? That what are the competition, what are the competition in the relevant market area where you operate, right? Where you primarily have your business. So if there is stiff competition in that relevant market area, then there are more industry specific challenges, right? Because the disrupted availability of raw materials would be there, because there is stiff competition. All of the businesses would try their best to source the material, source the raw material in the best form, right? From the best vendors. So there might be a disrupted availability of raw materials, or if not, then there might be disrupted availability of good raw materials, or a raw material of certain sort, because because the competition is stiff, and there are a lot of players to begin with, right? The competitive rates would also be a factor, right? Because you cannot have a huge factor in profit when there is stiff competition, right? You have to minimize your profit in order to increase your market share in a condition where competition is stiff. So all of these issues you have to take into consideration. You have to see that how these issues can be dealt with. You can have a lot of vendors in your contact, right? You can have a pool of vendors from whom you can source your raw materials, right? Because if you have only one or two, then there is a possibility that they can have monopoly on price, or they can have monopoly on the delivery schedule, or they have onerous terms and conditions. But when you have a pool of vendors who are providing the same quality materials to you, then you can pick and choose between those vendors, and the terms and conditions which are most favorable to you. You can choose those terms and conditions, because you have a lot of other options from which you can source your materials from, right? So these are the things which you can take into consideration. You can increase your presence of the businesses from one relevant area to other relevant areas where the competition is not that stiff, right? You can increase your presence on online platforms where the expenses are not too huge for maintaining the presence on an online platform, right? Because maintaining an offline presence is far too more expensive than maintaining an online presence, right? Because you have to take care of the rent, and you have to take care of the workforce that you have to employ in your shops or your enterprises. But if you have your presence on online stores or online platforms, let's say, then the relevant market area significantly increases, right? The relevant market area now would be the online platform and the outreach that the online platform has, upon which your markets or upon which your market or products are listed. So these things you can adopt internally. You can take into consideration for minimizing the competitive rates, or minimizing the possibility of disrupted availability of raw materials. Going forward, I've seen the MSMEs suffering primarily of because of this reason, which is no bargaining power with buyers to negotiate terms accordingly, market share reductions, alternative materials, or service against that of MSMEs, etc. I've seen the MSMEs being micro, small, and medium enterprises, which are around which are almost the smallest kind of enterprises which operates in our country. However, it is smallest kind of enterprises which operates in our country. The whole, if we take into the consideration the class of the enterprises which constitutes MSMEs, then the MSMEs contribute the largest factor to our economy, right? Because they're, they in isolation, these MSMEs might look small to you as an enterprise, as a market share, as uh, some enterprise, as if you take into account the turnover generated by those enterprises, or the investment made in those enterprises, right, is not significantly huge. But then these class of MSMEs, if taken together, all of them, then you can see that the MSME sector contribute the most majority contribution in our economy, in our country's economy. So we know that, however, these enterprises are not streamlined as it should have been. But however, these MSMEs are the largest contributor of the economic chunk in our country, right? So, as I stated, that MSME in isolation are not huge, significantly huge enterprises, right? And many a times, micro, small, and medium enterprises do enter into transactions with, let's say, huge conglomerates or huge industries, right? Uh, that the huge industries, if they are entering into a transaction with, let's say, significantly smaller industry in size or market share or quantum of investment or turnover, then the small enterprise do not have that much of bargaining power to bargain the terms and conditions as per its own tailored needs, because there might be a lot of other options for that big conglomerate to get into transaction with, because the small enterprise might be replaceable easily for that conglomerate. I've seen this reason. I've seen due to this reason, the MSMEs have to agree to uh, many a times onerous contracts, and the contracts under which the terms and conditions are highly inclined towards one party's needs and convenience, right? So these things have to be kept in mind. You have to negotiate terms accordingly. You have to push for negotiations. You have to push for accommodating your terms and conditions, which are tailored to your needs and convenient for yourself. So all of these things have to be taken into consideration. Next is ineffective correspondences during a transaction, lack of recorded communications between parties, reserving the right to claim liquidated damages, if any, lack of acknowledgement from the buyer regarding unequivocal acceptance, etc. Now, ineffective correspondences constitute a lot of correspondences which would have been done in a more effective manner, but just because of some or the other reason, you have not made it a point to communicate communicate those things with the other party, right? So let's say if the delivery schedule is delayed by the other party in making payments to you after you have raised an invoice upon that other party, then it is your duty for them to it is your duty to communicate with them that after 45 days, or after even 40 days of time, that the credit limit restricted by the statute is only of 45 days, and after 45 days you're liable to pay me three times of interest amount, and if you're not making timely payments, then all of these liabilities would incur, and you'll have to pay me after including the interest amount. So all of these correspondences must be done at a relevant time, when that is the appropriate time for making that correspondences, right? So if a buyer has made an issue that after you have let's say delivered them with some construction pipes to for construction pipes to them, and after 15 days or 20 days, or let's say 25 days, they come to you and they say that we do not want these pipes because these are not as per our needs, and please take it back and we'll not pay you. So all of these instances can have a very huge possibility, right? So all of these correspondences come into play. All of these effective correspondences come into play in a most effective manner, that the things which have to be communicated should be communicated at a relevant time. Why I say this? Because the act the MSMED Act says that if 15 days, after 15 days, when you have delivered some goods to, let's say, a buyer, and till 15 days, the buyer has not come to you and has not communicated of any deficiency or any shortcomings in the quality of the product, or in the manner in which he had expected the products to be, then beyond that 15 minutes, sorry, 15 minutes, I'm saying beyond that 15 days, the buyer cannot come and raise these issues, because it is considered as deemed acceptance. It is considered as unequivocal acceptance, right? So I'm saying that make it a point that you effectively communicate after delivering your goods to the other party, that you have 15 days of rectification period. And during these 15 days, if you have to go through any checks upon these goods which I've delivered it to you, you can do so. And if you have any shortcomings or deficiencies which you want to bring into our notice, then you can do so in within 15 days, right? And if you haven't done this in 15 days, then it might be deemed as an unequivocal acceptance, right? So this you can include it in your contract. This you can effectively communicate after delivering your goods. And this is also there in the statute, right? So all of these things you have to be aware and adapt with reserving your rights, right? Because you have to let the other party know that you are pressing upon your rights too much, and you're not letting these rights go. Just because you're not pressing these rights enough, it might be that they are considered to be waived by some of the adjudicator, right? So this is not a very accepted practice to do so, but then you cannot you must take precautions, right? And effective communication wouldn't cause any harm to you, right? So for effectively managing your business, you have to adopt this effective communication strategy, that you communicate effectively whatever your rights are, whatever rights you want to reserve in respect to any transaction or in respect to any breach of the contract, right? Lastly, difficulty in realizing payments from buyers, cash transactions, etc. So, difficulty in realizing payments from buyers. So, all of these challenges leads to what, the difficulty in realizing payments from buyers, right? Because you are losing out on a lot of effective tools which would have streamlined your businesses, right? And if you have ignored these tips and suggestions, there is a higher possibility that these issues would arise, the issues of delayed payment, defaulted payments, right? Also, I look down upon, I frown upon cash transactions taking place in businesses, right? I've seen a lot of businesses dealing in cash transactions where there is no record of receiving payments or making payments to the other party. And those are the payments which you make through cash transactions, or let's say which do not have any records to any records to prove the transaction that you have paid or you have received certain amount in cash. Then it becomes really difficult for the party to prove that they have paid or received this much of amount in cash, because there is no record of the same, right? So please keep in mind that as far as it is practically possible, deal through deal in any transaction which is not cash transactions, because cash transactions do not have any trace for you to follow, right? So cash transactions, I strongly advise you not to deal in, right? Coming to the other slide, the consequential effects due to these challenges, right? So what are the effects which you face after these issues have already arisen, right? When your payments are stuck, when your payments are defaulted, when your payments are delayed by some other party, then what are the possible outcomes of it? What are the possible consequential effects that you'd face, right? All of these things are included in this slide, right? And I don't have to go in detail about all of these consequential effects, right? Because these are too much basic effects that you can relate to. If you're not getting your investment, or not getting your hard-earned money, genuine amount that you have incurred in expenses in manufacturing some goods, or performing services to the other party, then you must get that amount to break even, right? To generate a profit for yourself, to pay back to your workforces, to contribute an amount from that money towards your rent, or towards the overhead expenses of your offices, right? So all of these things have consequential effects. All of these challenges, all of these issues, the issues of delayed payments have a lot of consequential effects, and we'll discuss those. The first is lack of financial resources. I do not have to even substantiate it. If you're not getting delayed, if you're not getting payments on time, if you're not getting if your payments are defaulted, then it's directly proportional that you will have lack of financial resources. Be be it your business or enterprises is too rich, or generating enough profits, but then if for one transaction the expenses that you incurred in making that transaction successful has not come back to you, then it is practical that you have a lack of financial resources, because you have incurred more expenses than you should have earned, right? Because you have not earned that component, you have not received that component as far till yet. So you have a lack of financial resources. The second one is lost claims due to not having enough evidence materials on records to prove default. As I stated, that due to not having recording of the transaction, not having enough documents to reflect the transactions between the two parties, the transactions that you entered with that other party, your claims might be lost, right? Because you cannot say that you had given him a lot of, let's say, five pipes which are extremely valuable in nature, and because you do not have any documents or any invoice or work order to prove that such orders were placed onto you, and you delivered such pipes. So if those documents are not available to you, then it becomes really difficult for your advocate or even for yourself to prove that transaction, that this transaction has taken place in this manner, right? You might be able to prove certain bits and pieces of the transaction, because there is always some traces which are there in practical scenario, right? Because you must have had ability when you were delivering that pipes. So you might prove bits and pieces of the transaction, but the transaction, how it should have been proven, or how it should, or how it was entered with the party, what having in mind both the parties entered into transaction, those things you wouldn't be able to prove effectively, right? Because you do not have any documents or recording of those terms and conditions, right? So that is the second one. The claims being undervalued, this is the same thing, that if you're not able to prove the claims in the manner that you should have, then the only bits and pieces that you have proven would be taken into consideration, right? So a lot of times your claims could be undervalued. So let's say if you would have delivered, let's say, 25 pipes, but you just have a delivery schedule under which you stated that you have delivered pipes, but it is not stated that how many pipes you have delivered. Then let's say if the opposite party has given the submission that I have only received 20 pipes, but you cannot prove it anyhow that you have given 25 pipes to the other party, then the five pipes, the value of five pipes would be undervalued, would be disputed, right? And it depends on the decision of the arbitrator or the adjudicator at the end of the day. But then the award, if you'll get any, has to be substantiated from the losses, has to be substantiated from any document, from has to be proved that you have incurred this much expenses, or you have incurred this much losses, in order for you to claim those amount in award, right? So a lot of time your claims are undervalued. Loss of damages liquidated for breach of terms of the arrangement by the buyer. So loss of damages. I've included loss of damages in MSME a lot of times, and I've a lot of times stated that you can ask for liquidated damages under the MSMED proceedings, but that is something which is not very clear in our law, right? I've read cases where it is stated that due to due to prevention of multiplicity of proceedings, there should not be any reason why MSME should only restrict its jurisdiction to delayed payment. Why it should not get into the details of liquidated damages? Because if you were to approach MSME for delayed payment and then liquidated damages before other arbitral tribunal, then it will multiply the proceedings, right? Then it wouldn't make sense. So I've seen several case laws where the courts have stated that the MSMED, being an arbitral tribunal, can look into and can delve into the issues of liquidated damages. But I'm not very sure about this part, because MSMED Act in FAQs, or in their website, excludes the liquidated damages part, right? Because they say that you cannot ask for damages under these proceedings. You can only ask for delayed payment issues, right? So that is the part which is not clear, and only any high court, or even Supreme Court can clear it, because the high court would have restricted jurisdiction to that state only. So this, you kindly keep in mind, that a certain times you even lost damages because you have not made effective communication. That once you've started suffering losses due to delayed payment, you must have had intimated the other party that there are dominoes effect on your businesses. There are cascading effect on your businesses. You're suffering losses just because the payment are not made on timely manner. And there are uh, it leads to a lot more losses, right? Because uh, you you do not have financial resources enough. You might not have financial resources enough to go and outsource raw materials, to pay to your workforces, to spend on your marketing strategies, or in your advertising strategies. It might hamper your whole production, or whole service unit, right? So all these liquidated damages have to be communicated effectively, in order to, if you're thinking of going and demanding these liquidated damages, you must reserve your rights to these liquidated damages at a time when you are suffering these losses, right? As I stated, liquidity crunch in the operation of businesses, as I stated just now, that you might not have enough money to buy raw materials, or you might not have enough money to pay to your laborers, or manpower, or you may not have enough money to deal with your overhead expenses, like electricity charges, water charges, rent charges, where your businesses operate. And so all of these liquidity crunch, you can see if the issues of delayed payment, defaulted payment, stuck payment have arisen in your businesses, right? So going forward, not able to realize the actual amount as reflected in the turnover generated by the MSMEs, hampering the expansion and growth of business, right? So as I stated that your turnover generated by the MSME, by the books, if we looked at the books, would be huge in number, right? But the same amount you have not realized in your business, because those payments are stuck. It is only reflected in your books and accounts, and due to which your certain plan for expansion and growth, if things would have worked out perfectly well or normally, if you would have gotten the payments on a timely manner, then it might have worked out for your plan of expansion and growth. So it also hampers the expansion and growth of the businesses, because you have a liquidity crunch at the end of the day. And the things that you the amount that you wanted to save to spend in expansion and growth is not available to you for doing so, right? So it hampers the expansion and growth of the businesses also. It gives you minimal profitability, because as you say, as I stated, that when you have liquidity crunch, then you'll have to make the ends meet, right? And your profitability would get minimal, because it has cascading effect, right? Your profit from other transactions would have to be appropriated in uh, making good this transaction, where the payments are stuck, or defaulted, right? So it significantly would reduce your profitability, right? After um, after this point, not taking proper and relevant professional consultations, resulting in losses. Now, I do not want to make the entrepreneurs feel bad, or enterprises feeling bad due to this, but I've seen this as a major concern for many enterprises, or entrepreneurs, because what they think is that we are starting a businesses, we are not even generating a lot of turnover, or we are not generating a lot of money. So for a certain period of time, they do not even think of legal or other professional consultations, which due to which they result in huge losses sometimes. I'm telling you that I've seen many clients who have gone for transactions without any agreement, who have slept over their rights, who have had defaulted payments and issues of delayed payments, but just because of laziness, and I do not know for what reasons, they do not approach professional consultations, and sometimes the claims get barred by limitation, or sometimes you just do not go and consult, and I've seen people that they do not want to spend a single penny on these professional consultations even when their payment are stuck. So it is fine for them if the other party has kept their payment and not paying them, but then they wouldn't want to pay any lawyer or a CA or a CS to get that payment recovered, right? So all of these things you have to keep behind, right? Because you're running a business now, and to have professional engagements and to have these professional consultations is in place is a lot more helpful to your businesses than you can think of, because because there are industry specific regulations. If you're into fashion industry, the intellectual property rights for you are of immense significance, right? Because you have incurred expenses, a lot of expenses in creating a brand name, and if some other fashion brand infringes upon that brand name, then your brand name can be diluted. But then a lot of entrepreneurs, a lot of enterprises are not even concerned of these rights, because they are not even exposed. They do not have the particular knowledge that how these things safeguard their businesses, how these things in a long run can be very much helpful for their businesses, right? So all of these things I would suggest you to go and to consult a professional. I'm not saying that go and consult a professional which you are suggested or which you are advised. It is always your prerogative as a client to go and choose professionals, right? So it is not necessary that which professional you are choosing. Just keep in mind that the professional should have expertise in that relevant field, and go and consult that professional, because you cannot fathom your mind around the compliances, the industry specific regulations and rules that you have to comply, and many other things that you cannot fathom your mind around, being an entrepreneur, or being an enterprises, that the professional consultations can give you, right? So all of these things are very much helpful. And going forward, ineffective workforce due to lack and wastages of valuable resources. So I'm telling you that this is a very basic issue, which from which a lot of MSMEs suffer, right? Ineffective workforces. So always invest in your workforces in the most effective manner, right? Because your workforces constitute your businesses. Your business is as good as the workers of your business, right? So always be careful of the fact that you're employing good people. You're employing people who have certain expertise in the area that you expect them to work under, right? So having an effective workforce can significantly increase your value of the resources, right? So this has to be kept in mind. The last one is the legal troubles due to ignorance or no knowledge of various industry-specific mandatory compliances. As I stated, that many industry-specific regulations are there. If you're into food and beverages, then you have to comply with the FSSAI regulations and other regulations, right? If you're manufacturing any electronic devices, then the ISI certifications are there, the ISO certifications are there, the Bureau of Indian Standards Act are there. So all of these compliances, various industry specific mandatory compliances, you have to know, right? Because you're operating in that industry specific area, right? So all those laws operating in that specific areas, if, let's say if you're manufacturing into drugs or medicines, then you must have to comply by the Drugs and Cosmetics Act, right? So all of these industry specific regulations you have to be aware of, right? And how would you ascertain that you have had all the compliances that are required? That you can only do so when you go and consult a uh, relevant professional who is working in that industry specific area, right? So all of these issues are consequential effects which uh, which you face because of the challenges that I discussed earlier. If you are not adopting those, these are the consequential effect that it entails, right? So be aware of these consequential effects. Keep those challenges and issues in mind, that you have to streamline your businesses. You have to significantly reduce the possibility so that these issues do not arise in the first place, right? Now going further, solutions and way forward to overcome challenges, right? So preventive measures, as I what we have discussed by far are preventive measures, right? All of these things you can adopt internally in your operations of the businesses, so that your businesses are streamlined, are managed effectively, and these issues of delayed payments are reduced significantly. The possibilities of it getting it coming into picture gets reduced significantly, right? What are those preventive measures? I'll just give a cursory reading of all these all these preventive measures which we have included here. To enter into a written agreement, as I stated, recording the understanding of terms of the parties. We have discussed this. Duly executed and properly stamped and notarized. So all of the agreement has to be duly executed. Duly executed means that both the parties have to be signed. Both the parties have to sign the agreement. It has to be properly stamped. Now there is a stamp duty paid on certain type of agreements. If you'll uh, refer to the Stamp Act and you'll go to the schedule of the Stamp Act, you'll see the agreements are classified under a table, and stamp duty are applicable in against those specific agreements. So as per that table, if there is any stamp duty to be payable on that agreement, you should pay that stamp duty, because in a recent Supreme Court judgment, the Supreme Court has stated that arbitration agreement which are not properly stamped are not valid in law. So it cannot be taken into evidence till the time it is properly stamped. It has to be impounded. Then you have to pay the shortfall stamp duty and the penalty, after after which only that stamped document can be taken into can be taken as an evidence, and can be relied upon, right? So stamp duty is pretty much important to be paid, and notarized, right? You have to get it notarized. You go to any court or tribunal which are functioning in your area, and you'll see that there are advocates sitting as notary, oath commissioner, and they do affidavit for you, right? So if you're notarizing your agreement, it gets into the records of the government. So there's a record of your agreement being registered in government record also, right? So now the other party cannot come and say that, oh, these are not my sign, or I have not signed on this agreement, or these agreement or this agreement was not like this, because there is a record of that agreement being notarized on that day. So it is already reflective in the government record. So all of these things have to be taken care of, because it just strengthens the agreement, right? A non-duly an agreement which is not signed by any of the parties, you cannot say that the other parties actually agreed, right? You can say, as per the conduct of the parties, that if you have exchanged those documents on mail and you have conducted your affairs as per those agreements, it can be said that you in a way accepted those agreements by your conduct. But then it becomes a very dicey ground. It's a very dicey ground, and it gets it complicates things unnecessarily complicates things, right? So be it, keep in mind that you execute the agreement, you get it properly stamped, and you get it properly notarized. As I stated, that the work purchase orders to be raised under such agreement, there has to be any work order, purchase order upon which you have started your work, right? So uh, it has to be it has to be it has to be taken into consideration that you receive those work order or purchase orders from the other party whenever you receive whenever you get an order for doing something, for manufacturing something, or performing a services, right? The work purchase orders have to be shared on an electronic medium too, even if a hard copy of the same is raised. As I stated, that many a times the other party just denies the existence of the work order. It says that I have not signed this agreement, I do not know of this agreement, and the other party is lying that I have signed this agreement. So in those cases, it comes to your aid when you have shared same agreement through two manners, right? If you have shared it on electronic mode, that let's say via an email, then it will always be in record, right? That it was shared on an electronic mode via mail on this date, right? And if a hard copy is produced, then the other party cannot say this at very much conveniently, that the the existence of the agreement cannot be questioned conveniently. Sorry, I'm sorry, that the other party cannot question the agreement conveniently at their own convenience, right? Because there is a reflective record of that agreement being sent or shared to the other party on an electronic medium, right? So these things have to be kept in mind, right? Recording each and every transactions, as I stated, that you have to record each and every transactions as an agreement. What clauses you can add into an agreement, right? You can start with the terms of the agreement, the obligations of both the parties, right? The dispute resolution clause, that how you'll resolve the dispute if any dispute arising of this agreement comes into picture, right? So uh, you can include dispute resolution clause, right? So you can include clause to notify defect or damaged goods or services rectification period, that whenever I've delivered you some goods in furtherance of any work order or purchase order, then you can include these clause to notify defect or damaged goods or services. Like you can write that if you have got any if you have gotten any defective or damaged goods, then within 15 days you have to intimate this to us. You can also include rectification period, that within 15 days, if the other party has brought into your notice any defective pieces or any deficiency in goods, then you can ask for a rectification period of, let's say, another 15 days or 1 month, under which you'll just go and you'll make things good, if they can be, if they can be made good. So if you can replace those goods, if you can make those things good as per the satisfaction of the other party, then the rectification period can have that operation. You can have that rectification period operation of 15 days, under which you can have the possibility of making those defective goods in goods good enough to be accepted by the other party, right? And if it is not, any defect is not pointed out in 15 days, you can add a clause that would say that if no defect or deficiency is pointed out within 15 days of delivery of the goods, then it would be deemed as an unequivocal acceptance, right? So all of these clauses you can add, right? And second one is being adept with communications, reserving of right, claim damages, if any, receiving acknowledgement of the due amount from the buyer, taking steps to resolve issues before the claims are barred by limitation, follows up on delayed payments, balance payments, intimation of applicable interest, not diluting its rights as a party by way of conduct, negotiating and careful of the agreed payment terms. As I've stated, I've discussed this already. right? That you have to be adept with the communications. You have to reserve the rights then and there at the very time when you are suffering losses. So if you have to reserve your right to claim liquidated damages, you have to do so by effectively communicating it with to the other party, right? That you have been suffering losses due to the default or delayed payment, and you reserve your right to claim liquidated damages because of that. So all of these communication you have to be adept with, right? So you have, if you can, you should receive an acknowledgement of the due amount. So let's say if 5 lakh rupees is due amount from the opposite party, then what you can have is you can ask for an acknowledgement from the other party saying that, okay, I do acknowledge that this much of amount I have to pay to you, and just because I do not have the funds with me right now, I do not absolve myself of this liability of paying this much of amount to you. So in that manner, you do not have to go to the adjudicatory body and to prove that claim, because if it is acknowledged by the other party himself, then you do not have to prove the quantum of amount, right? Because the other party himself has stated that I have to give you 5 lakh of rupees. Now, you have to be adept that the claims that the claims you're demanding from the other parties are not barred by limitation. Generally, it is 3 years for demanding or recovery of any money, or yeah, so the generally the limitation period is of 3 years. It gets extended if within those 3 year period you get an acknowledgement from the other party regarding the due amount, that yes, this is the due amount and we have to pay you this amount. If that acknowledgement has come before the limitation period has expired, within the limitation period, then the limitation period starts afresh from that acknowledgement date. So it gets extended, and yeah. So you have to keep this in mind, right? Because it might get barred by limitation if you do not, if you keep sleeping on your rights. Follow ups on delayed payments. You have to continuously follow up on your delayed payments, balance payments. You have to intimate the applicable interest, as I stated, that you have to intimate it to the other party that if you do not pay it to me within 45 days, I will, and you will be liable to pay 3 times of interest amount, right? As I stated. So you can include those into communication, right? So all of these things you have to effectively communicate to the other party, right? So I hope I am clear till now as far as preventive measures are concerned. Though all the preventive measures and solutions to be adopted internally in an enterprise, so as to effectively manage the operations and to significantly reduce the possibilities of facing these issues at the very first place, right? So we'll come to the next slide now. These are the suggestions, as I already discussed all of these, but I'll just simply touch upon this, that please take proper consultations from relevant professionals. Uh, it may have a legal secretarial audit. You might have a legal secretarial audit and verifying the industry specific mandatory requirements, compliances under different statutes, incorporating effective ways to execute agreements, communications, follow ups, receiving acknowledgement against purchase order, work orders, and delayed payments, right? So if you take proper consultations from relevant professionals, if you know about the relevant softwares that you can adopt, that there are a lot of softwares, right? A lot of software manages your contract effectively. A lot of software manages the last payment, the deadline from the deadline of generating invoices, or to send out intimation emails, or to follow up emails, right? All of these software you can adopt. You can adopt proper consultations from relevant professional. You can have a relevant professional on your payroll, so that it acts as your legal counsel exclusively, right? So you can have all these arrangements in place, right? You can have a legal and secretarial audit verifying the industry specific mandatory requirements. So the industry specific areas under which you perform, or you operate, it must have its own secretarial and legal compliances, right? So if you go to relevant professionals in order to get yourself advised, then you should do all of these for effectively managing your businesses, right? You can incorporate effective ways to execute agreement. There are a lot of software which through which you can sign an agreement digitally, and you can send it out the copy to the other party to sign, and when the other party is also signs it digitally, it gives both the parties a signed copy, a executed copy, right? So all of these effective ways you can adopt. Coming to the second point, to carefully assess damages clause in the agreement, computation of claims under various heads such as price escalation, overhead charges, machinery, and workforce idlement charges, etc. So I've seen many times that due to not due to not taking proper consultations from relevant professionals, clients a lot of time on their own go and fight arbitration, and do arbitration proceedings on their own. And it is not something that I look down upon, because arbitration is not that much expertise driven dispute resolution mechanism, right? So a lot of time, professionals who are not legal professionals per se, but are engineering professionals, or some other industry specific professionals, can have an upper hand in computation of claims of construction nature, such as price escalation claim, overhead charges, machinery and workforce idlement charges, etc. So all of these liquidated damages, all of these components under which you can claim damages from the other party, you cannot think of all of these being a layman, right? Or being someone who is not an expert in arbitration. So if you have an arbitration going on and you have to claim liquidated damages from the other party, then it is highly advisable to go and seek out professional consultations of industry experts, right? So if it's a construction contract, you go to construction contract arbitrators, or you go to engineers who are adept in computing claims of construction arbitration, right? So all of these things you have to take into consideration. You have to be well versed with all the schemes, benefit policies by the government affecting MSMEs, which are for the operations of MSMEs, operating around MSMEs, right? So all these schemes, benefit policies by the government, you have to be well versed with all the schemes, benefits, and policies, because any of those schemes, policies, and benefits might have an operation, or have an applicability upon your business, right? So you have to be well versed with all of those. To safeguard in the interest of the business, creating strategic assets, raising proper invoices with GSTI and UN, PAN, and be updated with statutory tax and other filings. So all of these compliances are statutory compliances, right? You have to have GSTI and UN, PAN. You have to have certain disclosures you have to make. You have to file certain forms of which are filled before GST department, or ROC, or MCA. So all of these are statutory filing, and you have to keep those in mind, that you do not miss those compliances, because most of the time those compliances, if missed, entails a penalty with them, right? So all of these things you have to safeguard the interest of your businesses by creating strategic assets. By creating strategic assets, uh, I mean is creating intellectual property, right? So if you have a business name, if you have a trade name from which customers generally associate with your business, right? So you must get a trademark for that, against that trade name, right? If you have a scientific process, or a scientific machinery through which you can achieve anything in a manner which has not been done earlier, or which is original in nature, so you can file for patents. You can have your artistic nature being safeguarded in copyrights, and all of these things you have to all of these things are assets in law, right? All of these things are called property in law, which are intellectual in nature. So all of these things, you all of by investing in these assets, you create these assets for your company, right? So all of these assets are called strategic assets that you can have for your own company. To create outreach with online presence, as I stated, right? Being adept with follow-ups for payments, I discussed this also. I do not think that we have to repeat this again and again. Lastly, is acquiring a post-dated check for the bill raised as a security measure to avoid delayed payment. Now it is a very unconventional way of securing your amount. A lot of entrepreneurs or enterprises, what they do is, if they are not very much if they're not very much satisfied with the if they are not very much like confident about the other party being paying on a timely manner to their enterprise or to them, then a lot of them, what they do is that they ask for a post dated check from the opposite party. They ask that you write a post date on the check, and you give a check of a certain amount, which is also the value of the works or the services or the goods that I have been delivering you. And you write a date which is post the date, which is post the date or the date on which the debt falls due. Let's say, so on 1st of October, I delivered certain 10 pipes to you, 10 iron pipes to you. Then what I can do is, after 45 days, which is the extended credit period in the statute, I can say that after 15th November, or I can ask for a check of 15th November for, let's say, 5 lakh of rupees, whatever the amount of the 10 value, 10 pipes are, whatever the value of the 10 pipes are, be it 5 lakhs or be it 6 lakhs. So what I can ask is, I can ask a check of that same amount of 6 lakh rupees, dated 15th November, which is after the 45 days, which is the extended credit period, to be given by the opposite party. And in case the opposite party, on the 45th day, is not able to pay me the amount, then what you can do is, you can go and you can produce the check to the bank. And if it gets dishonored due to lack of sufficient funds, then you end up with two options to have to proceed to have a civil proceedings, and to simultaneously to have a criminal proceedings against the directors, or the company, or both of them. Yeah, so all of these things, you please keep in mind. Let's move on to the dispute resolution, and the alternate dispute resolution mechanisms. Now, the external solutions, the solutions resolution of disputes. Now, what if the disputes, the issues of delayed payment have already arisen, and after even conciliating, after even taking all the amicable efforts from your side, the other party is not ready to give you the payment, and the payment is still delayed, defaulted, or stuck. Then what are the recourses you have to recover those payments? Now, I'll discuss those recourses. The first is recourse under MSMED Act. The second is proceedings under Section 138 of the NI Act, which is the proceedings for dishonor of checks if it gets dishonor due to insufficiency of funds. Third is insolvency and bankruptcy code. Fourth is arbitration and conciliation, general arbitration and conciliation. Fifth is civil suit for recovery of money, and the last one is summary suits. It's just the nature of suits. So, and last one is mutual resolution. Mutual resolution is nothing but the parties, without any facilitation of any professional, coming together on their own and resolving their disputes on their own. That is called mutual resolution. So, all of these things we'll discuss now. The first one is the reference of a dispute to MSEFC, relevant and important provisions of MSMED Act. So all of these relevant and the important provisions are not very much relevant to the presentation at hand, or the webinar at hand. So the relevant provisions comes from section 15, which is liability of buyer to make payment. which says that the buyer has to make payment to the supplier after the 45 days. So after the 45 days have been completed, then the liability is upon the buyer to make payments to the supplier. The section 16. Now section 16 states from which date and at which rate the interest would be payable. So it is in this section where it states, the legislature states that after 45 days, uh, after 45 days of delivering goods to the other party, from the date when the goods were delivered till the 45 days, and beyond those 45 days, so onwards 46th day, the rate of interest is applicable, and the rate at which is applicable is at the rate at which the interest is applicable is three times the interest notified by the RBI, which is somewhere around 6.25 or 6.5. I'm not very much sure. I'll have to check again, but it generally ranges between 18 to 18.5% if you multiply it by three times of RBI notified rates. So 18% or 18.5% compounded interest on monthly returns, right? So it has to be calculated on monthly basis. So that is how the interest is calculated, right? So section 16 talks of that. Section 18 states that if any supplier is suffering from the issues of delayed payment, that then under section 18, under section 18 of the MSMED Act, it can make a reference application before the MSMED, respective MSME FC, right? So Micro, Small, Medium Enterprises Facilitation Council is a council formed under this act, which hears out the issues of delayed payments of supplier. So if your enterprise is registered, let's say under in Gujarat, and your buyer is from Mumbai. Yes, you have delivered your goods and your buyer is not making payments, and it has been already 2 months, 3 months, or let's say it has been already 2 years now since you delivered the payment, and you are still awaiting the payment from the buyer. Then what you can do is you can, under section 18, go and file a reference application before the MSEFC online MSCFC online, and it would get registered in your respective MSCFC. So where the supplier resides, the MSCFC of that area has the jurisdiction to deal with the issues of delayed payment. Now, when you make that reference, what happens is that it gives the other party a notice to pay this much of amount. Now you have to, while making a reference application under section 18, you have to write down the due amount, the interest amount that you're claiming, and at how the interest came, how the amount fell due, when the amount fell due. All of these things you have to state. And the MSCFC, what they do is they give a notice with all those details to the other party, saying that the other party is demanding this much of amount from you, and you have certain, let's say 15 days, 30 days of time to get back to them, to make this payment, or to raise a dispute on this payment, right? So either they can make the payment after getting the notice, or what they can do is they can write a reply that, see that this claim I am not accepting. I do not think that I should pay you 10 lakh of rupees, or let's say let's 7 lakh of rupees. From my book of from my book of accounts, it is only showing 50,000 of rupees. So if you want 50,000, I can pay you 50,000, but I am not going to pay you 10 lakh of rupees. Let's say disputes such as this has come to picture, right? So what the MSCFC would do is it would give the reply received from the other party to you now, and would say that the other party has not given the payment but has replied uh, to your notice, and it states that they do not have any liability to pay 10 lakh of rupees as you have claimed in the reference application, and they're saying that they only have to pay you 50,000 rupees. Now you have to give a rejoinder reply to the MSCFC saying that no, this is how I feel that 10 lakh rupees should be given. I feel that the 10 lakh rupees is due, and just because the parties are not coming to uh, not coming to a common ground, then the proceedings might be initiated, right? So in this circumstances, two things can happen. The first thing is the MSCFC can refer both the parties to conciliation. Now, the MSME Act states that without having conciliation, you cannot directly go to arbitration. So, conciliation before getting into arbitration is mandatory in MSMED Act. But I've seen a lot of cases, MSME reference cases, where conciliation is waived because both the parties in their pleadings, even in their pleadings, had no common ground. Now, when you send the notice, the other party replied to the notice, right? Now the other party has replied to the notice and he has said completely different things which are in stark contravention to the details in your notice, right? So there it is apparent that both the parties are not coming to an amicable resolution or not coming to a common ground. So and after you have received the reply from that opposite party, you have again produced a rejoinder reply saying that okay, my claim is good and you have to decide this claim now. So doing conciliation in those circumstances is futile, if you'd ask me, because uh, the parties are already communicating with each other, right? And conciliation is nothing but there would be a conciliator. He would try and facilitate an agreement or a settlement between the parties. So it's natural, it's apparent that the parties have no common ground in between. The parties differ from each other on a huge ground, and it cannot be covered. So in those circumstances, going for conciliation would be futile and would be abuse of process of law. It would lead resources to wastages, because the conciliation in those cases would not yield any effective results. So the second case is the council would not refer you to the conciliation, but can directly refer you to the arbitration, in view that both the parties are already communicating with each other through notices, replies, and rejoinder replies, and there is no way that even in conciliation the parties would come and sit together and would come on a common ground. So in those cases, the arbitration can be initiated directly. I'm yet to say that what is the legal ground, whether that arbitration without conciliation uh, would be valid or not. But I believe that it should be valid, because I've seen MSME doing it, and it makes sense also that both the parties are communicating with each other, but they do not have any common ground to 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 settle the issues on, right? And coming to section 19, application for setting aside decree, award, or order. So when all the pleadings are completed, you have stated that this is my statement of claim, I require 10 lakh of rupees from the opposite party. The opposite party have given a statement of defense that no, 10 lakh of rupees is not to be given, only 50,000 of rupees to be given to the other party. Then the arbitrator would hear out both the parties, would decide upon the pleadings of both the parties and oral submissions of both the parties, and basis on those oral submissions and pleadings of the parties, he'll pass an award. Now he might pass an award of saying that no, okay, only 50,000 rupees has to be given, or let's say he says neither 10 lakh rupees nor 50,000 has to be given, but the other party has to give 5 lakh of rupees. So let's say the award states that 5 lakh of rupees to be given. So now the other party has the provision and has the liberty to go and challenge that award in section 19 of the MSMED Act. And all these proceedings would go as per the Arbitration and Conciliation Act. So all the proceedings which are there in the MSMED Act are governed under arbitration and conciliation. So as far as conciliation goes, the conciliation part of the act prevails. And as soon as the arbitration initiates, the Arbitration Act comes into picture, right? So the proceedings are governed as per the Arbitration and Conciliation Act. So if you know Arbitration and Conciliation Act good enough, you know that for challenging an award, you have to file a petition under Section 34. to challenge the award of to challenge an arbitral award, right? So you have to read with in accordance with section 34 and in section 19 of MSMED Act, make a petition or an application for challenging those arbitral award. Now, MSMED Act is different from Arbitration Act generally, right? Because MSMED Act is specifically for resolving disputes of delayed payment, which which the micro and small enterprises suffers. Now I must say the medium enterprises are also not given the benefit of coming to MSEFC. Now the medium enterprises cannot come for their recourses of delayed payment for the MSEFC, because the MSEFC only extends its benefits to small and micro categories. So if the opposite party comes wants to come and challenge that 5 lakh of award in section 19, the section 19 mandates it mandatorily states that without depositing 75% of that award amount, meaning that 75% of that 5 lakh of rupees, without depositing the 75% of that award amount, you cannot maintain an appeal in section 19. So in order to maintain an appeal, in order to challenge the award in section 19 of the MSMED Act, read with section 34 of Arbitration and Conciliation Act, you have to pre-deposit 75% of the award amount, right? And the courts have been very stringent while interpreting this provision, and they have time and again stated that it cannot be circumvented, it cannot be exempted. That if you want to challenge this award, it has to be mandatorily 75% of the award has to be pre-deposited before the courts. So it safeguards a lot of frivolous litigations, right? Because anyway the other party has to bear the expense, which is 75% of the total award amount. So a lot of time the opposite party, without going into appeal, generally settles the issue with the party, and pays out the amount, because anyway it has to pay the 75% of amount even to appeal, right? So this is a very good provision in order to safeguard frivolous litigations, and to keep the litigation in abeyance for a long time. So what the other parties used to, after getting an award, after they got an award, they have to pay 5 lakh of rupees. They would now challenge the award in the superior courts, and they would go into appeal till the very supreme court, and it would take around 10 to 15 years fairly. So just not to keep it in abeyance, just in order to ensure the timely realization of amount to the micro, small, and medium enterprises. I'm sorry, micro and small enterprises. The MSCFC, the legislation has introduced this 75% of pre-deposit provision, so that all the parties do not come into frivolous litigations, right? So, and the lastly, the section is overriding effect. The MSMED Act, being a special legislature, has an overriding effect uh, on Arbitration and Conciliation Act, right? So if there is an independent arbitration and conciliation clause in an agreement which you have entered with the other party, and you want not to initiate arbitration, but you want MSCFC to deal with your delayed payment issue, then you can file a reference before MSCFC. And just because that there is an independent arbitration clause in your agreement, it would not absolve the MSCFC, or it would not take away the rights of the MSCFC to deal with your case, right? So that is the meaning of the overriding effect. So it overrides all the earlier laws. So the MSMED Act being an act of 2006, and Arbitration and Conciliation Act being an act of 1996, it is natural that the MSMED Act supersedes the Arbitration and Conciliation Act, because Arbitration and Conciliation Act is older in nature than the MSMED Act. Now, coming to the next slide, recourse after dishonoring of checks under negotiable instrument act. Now it is a very general recourse, and I believe that most of you must have had some sort of idea of these recourses, or have some sort of knowledge of these recourses, that you can have section 138 proceedings for dishonor of checks for the reason of insufficient funds in the account. The section 139 gives the presumption that if you have received a check from any party for any amount, then the presumption, the section 139 presumes that the check which you have received is given in furtherance of discharging any liability or dues. So why would anybody give a check to you? So it presumes that the check is given to you in furtherance of discharging some liability or some dues of any party who has given you the check, right? So that is the presumption. However, it is rebuttable presumption, but the presumption generally works at the very first stage. It works for the person who have who have received check, right? Section 142 is cognizance of offenses, explanations. Important things to remember before resorting under an I Act. Jurisdiction is 142, clause 2. Procedure is that you have to make a complaint before Metropolitan Magistrate or GMFC. You have to mandatorily send a notice in 30 days to the other party, right? If you have not sent this notice, you cannot maintain an action in 138 because this notice is mandatory in nature. You have to have sent notice to the party intimating him that the check has been dishonored due to insufficient funds, and you demand the same payment from him for and you give them him a time limit of 30 days. After 30 days, you can have that proceedings initiated, right? Now, both the action can be taken against both the enterprises and signatory of the disordered check. So, this is the existing mechanism where you can initiate legal action against the company as well as the signing director of the company, right? Because it gives you the leeway to initiate the criminal proceedings against both the persons simultaneously, right? So it is a good way of securing your amount. So it is advisable that you keep posted checks for the amount that you have entered into transaction with from the opposite party. Coming to the next slide, recourses under insolvency and bankruptcy code. So insolvency and bankruptcy code is also a strong technique mechanism where you uh, when you file for insolvency of the other party. Now, there are some qualifying conditions for maintaining a application under insolvency and bankruptcy code. So, being a supplier or being a manufacturer of goods or being a service provider, generally the MSMEs come under the definition of operational creditor. Operational creditors are no one but operational creditors are defined under Section 5, Clause 21. Operational creditors are any creditors who contribute to the operation of the company, right? So if I have delivered certain goods to a company, or if I've delivered certain manpower to a company, or if me being an employee worked for a company for let's say 2 or 3 months, then all of these contributions have been made in the operations of the company, right? So me being contributed in the operations of the company makes me an operational creditor. And in the same manner, financial creditors are those creditors who give finances to the company, which has time value of money, right? So you'll have to delve deep into understanding who are operational creditors and financial creditors. I would not go too much deep into that for your ease of convenience. I would just say that anyone who is a supplier of materials, or a service provider, or an employee of the company, are generally covered under the operational creditors of the company, right? Section 8 is whenever you have a demand against any company. Now, insolvency and bankruptcy code cannot be maintained against any bodies, right? It can only be maintained against a company or an LLP, right? It only has operations restricted to a private limited company or an LLP, right? Or public company for that matter. So you have to keep it in mind that not all bodies can have an insolvency and bankruptcy petition maintained against them. It can only be maintained against a body corporate which is registered under the Companies Act or registered under the Limited Liability Partnerships Act. it is restricted to initiate insolvency and bankruptcy for NBFCs and banking financial institutions, even when they are companies, right? So it is specifically barred under the insolvency and bankruptcy code. And the other qualifying condition is that the minimum debt threshold, the minimum debt threshold should not be less than 1 crore of rupees, right? So if you have a minimum threshold which is less than 1 crore of rupees, then you cannot avail the benefit which is there in the insolvency and bankruptcy code. If your debt exceeds the threshold limit of 1 crore of rupees, which was earlier 1 lakh only in 2019, but it was increased in the COVID time, and it was increased till 1 crore of rupees. So if your debt exceeds 1 crore of rupees or 1 crore rupees, then only you are qualified enough to maintain a petition or an application against any company in insolvency and bankruptcy code. So what it does is it suspends the board of directors of the company. The insolvency and bankruptcy code ensures that a company is run by a efficient board of directors, and if any company is not being able to pay back its operational creditors or financial creditors in a timely manner, then the insolvency and bankruptcy code considers the board of director uh, to be not qualified enough to take that company anymore further, to take that company further anymore, right? So they suspend the board of director as soon as the company goes into CIRP, which is corporate insolvency resolution process. Then the board of director, the erstwhile board of director of the company, is suspended. The NCLT appoints a resolution professional in accordance with the insolvency and bankruptcy code, and that resolution professional assumes all the powers of the board of directors, right? So now what the RP would do, the resolution professional would go and would collate all the details of the company, would collate all the liabilities of the company, would collate all the creditors of the company, right? It would take out a public announcement in a newspaper, in an English daily, and in a vernacular language, intimating the public at large of CIRP of that particular company, and it would invite all the creditors to file their claims. So file their claims against that company, that look, I have 1 crore of rupees to recover, I have 15 lakh of rupees to recover, I have 10 lakh of rupees to recover, and after with all the relevant documents. And after receiving all those claims, what it does is it prepares a document which totally can be called as information memorandum. Information memorandum is nothing but it gives out information regarding a company's total valuation, assets, total claims, total debt, total liability, and all of these information are detailed out, and then it is floated in open market, and the other companies which are in the market can come and can suggest an arrangement to the resolution professional, and that these are the way I will resolve your these are the way I will pay out the creditors, right? So in this manner I'll pay out the creditors, and there are committee of creditors. The committee of creditors are generally comprised of only financial creditors. The operational creditors are not made part of the committee of creditors, right? Only financial creditors are made part of the committee of creditors. So the committee of creditors decide whether which arrangement would be benefit for that company, right? Would benefit would be good for that company, right? So if a company has, let's say, 10 crore of debt and 5 crores in asset, and the RP has given information memorandum, it floated information memorandum on an open market, then any companies can come and can suggest ways as to how they want the resolution process to be, how they want to resolve the how they want to uh, I what does it called? How they want to restructure the debt, right? Restructuring of debt. So how they will restructure those debts, right? So let's say if one company comes and one company states that I'll give you 12 crores of rupees I'll pay out 10 crores in total. I'll not take any haircut, and I'll pay out the creditors in full, and I'll pay out 2 crores more to be distributed as per section 53 of the insolvency and bankruptcy code. And all of these offers are considered by committee of creditors. Now some other company might come and say that I'll give only 8 crores of rupees, I'll take 2 crores of rupees in haircut. I am not able to pay out the all the creditors in full, because the total debt is of 10 crores, but I only have 8 crores rupees. So I propose that I give the I would restructure the debt only till the tune of amount 8 crores of rupees. So the committee of creditors would now evaluate all those offers, and would accept those offers which is best for the creditors in whole, right? So in that way, the company can be company can be revived by the resolution and by the restructuring of debts by going into CIRP. If the CIRP fails, no one comes and no one offers any amount, and no one is ready to revive the company from an open market. Then what happens is the company goes into liquidation, and the RP is then substituted by the liquidator. The liquidator collates all the assets of the company. It sells off the assets of the company, be it on a going concern, be it on not on a going concern. It sells out the assets of the corporate debtor, and it distributes accordingly the proceeds of the assets to the creditors as per it is given under section 53. Now section 53 is waterfall mechanism. It gives out the criteria. It gives out the priority under which the creditors has to be paid. So first priority is given to the financial creditors, the second priority is given to the secured creditors, and so in those manner, the proceeds of the CIRP or proceeds of the liquidation has to be distributed between the creditors, right? So this is the resolution process under insolvency and bankruptcy code. I would say that enactment strictly not to be used for recovery, but only for resolution of debts. The courts have time and again stated that the IBC is a special legislation for resolution of debts, for restructuring of debts, and it is not for recovery of debts. You can go into SARFACI, you can go into other laws which are there, but you cannot come into insolvency just for the purposes of recovering the debt. However, this stance of courts have been diluted after certain recent judicial pronouncements, where it states that if debt and default are proved, then there is no discretion left with the NCLT to reject the application. It only has to accept that application. So if there is a debt and if there is a default, it doesn't matter whether the IBC is used as a recovery mechanism or a resolution mechanism. Uh, the NCLT do not enjoy unfettered discretion to reject the application, right? So that has to be kept in mind. Realization of amount is not guaranteed based on the resolution plan, if any, or distribution of proceeds as per waterfall mechanism. Now, the IBC is used as a strong arm tactics to get the corporate debtor on a negotiating table, or to create enough pressure on them to make them release the payments which are due for a long time. But once the CIRP is initiated, operational creditor do not have a lot of leeway, right? Because they are not part of committee of creditors. They do not have any decision making authority in all the CIRP or liquidation processes. So many a times the operational creditors do not get full realization of debts. There are a lot of large haircuts that have been introduced by a lot of that have been accepted by the financial creditors, right? So a lot of times the operational creditors who had around 10 crores of claim might only get something around let's say 2 crores or 1 crores in lieu of that claim of 10 crores. So it only make sure that whatever the amount in section 53 you'd not get lesser than that amount in any other way. So the least amount what you can get in section 53 is the amount that is ensured that you will get in lieu of your claim, and you cannot say that your claimed amount would be the realized amount. It is not guaranteed. So uh, we'll move to the next slide. Resolution by way of alternate dispute resolution, as I stated, that the proceedings under MSMED or MSEFC is governed by Arbitration and Conciliation Act. There are certain important provisions that I would like to discuss, but then I would just briefly touch upon these because these are not very much relevant to you. The section 9 is interim measures for courts. So let's say you can approach if your arbitration has not been initiated and you require the courts to give you interim measures. You require some interim relief, and there is an independent arbitration clause in the agreement. Then it is natural that you cannot go to courts. You have to invoke arbitration clause, right? Because all the disputes would be decided by arbitration. So if arbitration tribunal has not been constituted yet, and you have invoked the arbitration, but the nature of the case is such that you want an interim relief, and in any delay would adversely affect you, and it would take some time for the arbitral tribunal to be constituted. Then in section 9 you can approach to the court, say under interim measures that you want an interim measures, and it can only be done till the arbitral tribunal is constituted. After the arbitral tribunal is constituted, all the issues that you have in regard to the agreement, it has to be decided by the arbitrator itself. And section 16 reflects and manifests the same thing, which says the competence principle. It states the competence of arbitral tribunal to rule on its own jurisdiction. It says that even if you have any jurisdictional issue, if you want to state to an arbitrator that you are not qualified enough, you do not have jurisdiction to deal with this issue in arbitration, then all of those issues can also be dealt by the arbitral tribunal itself. So, arbitral tribunal is competent even to rule on its own jurisdiction. So, this has to be kept in mind. And section 17 is interim measures ordered by arbitral tribunal. So once arbitral tribunal is constituted for any interim relief, you cannot go to courts. You must go to section 17 before the arbitral tribunal. So that is section 16. Section 11, I missed. Section 11 is appointment of arbitrator, more particularly in section 11(6), clause 6, where you can approach the High Court of the respective jurisdiction, because High Court has the original jurisdiction to appoint an arbitrator in any matter, particularly the Chief Justice of that High Court. And in that section, you can go for appointment of arbitrator if you have not agreed upon an arbitrator in the agreement itself. And the last is section 34. We have discussed this. That section 34, under section 34, you go and you challenge an arbitral award. The grounds for challenging the arbitral award are too low, and it's exceptionally narrowed down after recent amendments of 2015. And there are only three grounds on which arbitral award can be set aside. And let me say to you that even if arbitral award is not good in law, it does not become a ground good enough to set aside that arbitral award, right? Because courts have stated that the arbitrator doesn't have to be someone who is an expert in law, but an arbitrator has to be someone who is an expert enough to understand the dispute and to decide the disputes between the parties. And you cannot expect the same level of legal proficiency from an arbitrator that you can expect from a judge. So even if it is wrong on some legal point, then it cannot be a ground solely that it should be set aside, right? So that is a settled law. Conciliation is section 61 to 81, that is in another part of the Arbitration and Conciliation Act, and the conciliations are governed under those provisions, the provisions between 61 to 81. Now I'll come to the civil suit and summary suit. So civil suit and summary suits are the classic way of recovering any delayed amount. So if you do not have any independent arbitration clause, if you have registration of MSME, which has been done after you have raised an invoice to the other party, then you cannot go to the MSEFC also, right? Because it's been barred by Supreme Court in one of its recent judgment. It says that if your invoices are of a later date than your registration, then for those invoices you cannot come to MSEFC. So your invoices which are in dispute have to be prior to the date of your MSEFC MSME registration. So if you do not have a prior date invoice, if you have a post date invoice after your registration, then you cannot go to MSEFC. If you do not have an independent arbitration clause in your agreement, you cannot even go to arbitration and conciliation. Then the only recourse that you have is civil suit for recovery of money. Now, what is summary suits? Summary suit is a kind of suit. Summary suits are suits where it is clear enough, it is apparent enough from the records that the opposite party do not have any virtual defense, that it is already on the face of it clear. And let's say if you have an acknowledgement by the opposite party saying that I have to pay you 5 lakh of rupees, and then you haven't received any amount from the opposite party after that acknowledgement, then you can go to summary suit and you can say that there is no virtual defense available to the opposite party because he himself has stated that I have to pay you 5 lakh rupees. Then what summary suit does is the summary suits does not give the right to defend to the opposite party to come and defend the case, right? It just hears your part, and basis on the document that you have produced, it passes an award, right? So it's a special class of suits which is called summary suits. Even if you do not succeed in getting a summary suit listed, your summary suit can worst be converted into a normal suit. So this has to be kept in mind. The CPC and Commercial Code Act are almost similar enactments, and the commercial divisions are being made separate from civil divisions, and there is an amount after which, if you precede that, if you succeed that amount in dispute, then your case goes into commercial division of that. District and sessions court, district judge, right? District court. So the jurisdiction are different, the provisions are different in CPCs and Commercial Code Act, but in nature they are one and the same. So that was all which we had to discuss. The quick tips and suggestions are: kindly update your invoices with GSTIN, UAN, PAN numbers. Kindly write PAN numbers on the invoice, address of the registered office on the invoice, MSME registration on the invoice. All of these things you make sure that are reflective on the invoice. You please arrange for a effective communication tool, or arrange for an effective communication way with the parties. Always have a pre-estimate of an amount which can be claimed as damages in case of delayed payments. I'll not substantiate it because it's not too much relevant. Always try to settle amicably on the basis of facts, right? Always try to safeguard interest by registering trademarks, design mandatory compliances. As I've stated, we have already discussed this. And always try to amicably settle the issues as far as this, it's practically possible, right? Because whenever you enter into any sort of dispute resolution, you'll have to get professional help, and you have to hire a professional, which would entail a professional fee. So it's better that you settle the issues amicably, mutually, till it is practically possible. If it's not, then you do not have any other recourse other than to come to professionals and to initiate legal proceedings. But as far as practically possible, all the disputes are advisable to be mutually decided and settled, right? So I would end my webinar with this. Thank you so much.
Thank you so much, sir, for sharing so much good knowledge.
Thank you. Thank
And
you.
we are getting a very good response and feedback as well. So, if someone has any questions, so they can ask. So there are few questions if you can see in
Sure,
the chat
sure,
box. So if we can
sure,
proceed with
sure.
that.
I will. Okay. Mm, if one has to do trading and after sale they provide the service to that product, then which category they fall? Naturally, they should fall under the services category because in the industry classification codes that you mentioned while registering your classification, they ask you for NIC codes, National Industry Classification codes, right? And there are specific codes given for industry specific works. So I've read this in industry NIC that if someone gives out after sales services, then it is covered under the services aspect, right? So I would suggest you to get a registration for service providers rather than trading, because in that way you can get the benefit of availing the MSCFC procedures.
Thank you so
And
much, sir. And
yeah,
there are few questions in the question and answer category as well, if you can see.
if
I hope.
turnover is below than 100 crore, can we file MSME application on MSME portal for delay payment? Kindly guide. I'll just let you know. Just a second. No, you cannot. So, as I stated, that after 50 crores, it goes into medium category classification, right? And medium categories are excluded from coming to MSEFC. They are not given the benefit of coming to MSEFC for resolution of their delayed payment disputes. So, I'm really sorry. You have your turnover is far beyond the 50 crore limit, right? So it cannot be taken to MSCFC for resolution of disputes. You can initiate arbitration, general arbitration. SK
Okay.
Agarwal says, I need legal advice for delayed payments. Sweta or Megha can connect you with me after the webinar ends or tomorrow. Then we can talk and I can advise you accordingly.
Yes.
Gaurav Kumar, yeah, Gaurav Kumar says, as per the contract, payment is supposed to be done within 20 days, but client is making the payment after 2 3 months. Suggest what can be done. It's monthly payment and client delays every time like this. So you start calculating the interest on the delayed amount, right? And you ask for those interest amount to the from the opposite party. You say that if you have delayed after 45 days, then I am liable, I'm entitled under the MSMED Act to receive 3 times of interest payment. And this is under law. You cannot circumvent this. So all of those delayed payment interest component you can still claim. You can write a notice and you can ask for those payments, ask for those delay interests from the opposite party, saying that you have made substantial delay in each and every payments, and all and according to the delay made, according to the number of delays made in making payments to invoices, making payments against each invoices, you can calculate the interest amount and you can raise an invoice for the interest component.
Okay. And thank you so much, sir. The two people has raised their hands, Nirmala Sharam and Ashok Nanda, sir. So if we can answer their queries, that would be
I
great.
guess pending payments on account of security deposit while bidding is covered here. I guess it's covered here because because if they are delaying it after the contract stipulates. So if in generally bidding documents you would see that they state that after this much of amount, if you have not succeeded in bidding, then we will return your security amount. Then if that period has already expired and they have not returned your security amount, then you can, yes, file for a reference before MSCFC. Is there any limitations for the amount outstanding for IBC case file? Yes, there is lower limitation, that is 1 crore of rupees. If your amount is less than 1 crore, you cannot come to IBC. And what is the time limit for raining delayed payment along with interest? I've not got this question very much completely, but I guess you're asking that what is the time limit uh, for us to compute the interest on the delayed payment amount. It is 45 days. So after 45 days, if you have not received the payment, you can apply the interest component, which is three times the bank notified rates, and you can calculate it on the principal amount after onwards 46th day. So I hope I'm clear. I've answered all the questions. Now we can have
Uh,
the people who
Sir,
have raised their hand.
Nirmala ji wants to talk. Uh,
Sure.
please ask your question.
Sure, Nirmala ji. Can you unmute yourself first so that I can hear you?
Karthik, I hope you must have done the unmuting for Nirmala ji. Nirmala ji, are you able to hear? सर आप सुन पा रहे हैं?
No, Nirmala. Yeah, I can hear you, but Nirmala ji is on mute. It shows on the icon.
Karthik, please unmute Ashok sir. अशोक सर आप क्वेश्चन पूछ सकते हैं अपना.
Yeah,
हेलो
it's on mute.
हेलो सर मैं
Hi, Ashok. Hi,
हाँ
Ashok sir.
सर ये एक्चुअली मैंने एमएसएफ में केस किया था. गवर्नमेंट का एक ऑर्गेनाइजेशन है.
Mm-hmm.
सर जी वो एक्चुअली मेरा भी अवार्ड हो गया था मेरे को फेवर में कि वो ऑर्गेनाइजेशन को बोला था कि आप यू प्लीज पे. बट सिंस लास्ट
Okay.
2 years 2 and 3 years आई एम रनिंग बिहाइंड दैट ऑर्गेनाइजेशन. दैट इज ए स्कूल एंड मास एजुकेशन जहाँ पर मैंने वो 1 साल का सर्विस दिया था. वो 50% पेमेंट करके और 50% नहीं दिया ड्यू टू सम अदर रीजन. तो उसके लिए मैंने क्या करूँ अभी?
उसके लिए आप इन्फोर्स करा सकते हैं. इन्फोर्समेंट ऑफ अवार्ड होता है. जब आपको कोई भी आर्बिट्रल अवार्ड मिलता है ना, तो यू हैव टू गेट दैट अवार्ड इन्फोर्स्ड. सो वेयर इज दैट एजुकेशन इंस्टीट्यूट लोकेटेड? आई मे आस्क यू.
हाँ, it is in Kendrapada, district of Odisha state.
So you'll have to file an enforcement application, enforcement proceedings in that district. तो उसमें क्या होगा कि आपको वो अवार्ड जो है, यू हैव टू टेक दैट अवार्ड इन दैट डिस्ट्रिक्ट ऑफ ओडिशा. यू हैव टू फाइल एन enforcement of that award.
Sir,
So while
in
enforcing, yeah,
sir
sorry.
in Kendrapada district or in the Odisha High Court?
No, you do not have to go to high court. You have to go to district court of
Okay, sir.
where the defendant resides, where the opposite party resides, where the opposite party has the registered address. You
Okay.
go to that district and you go to that district court and
Okay,
you
sir.
file an enforcement application.
In
And
Kendrapada, sir. Sir. Right.
हाँ, enforcement application. तो
Sir.
उसमें you have to detail out all the assets that the institution holds. तो
Right.
जैसा जैसे मान लीजिए कि इंस्टीट्यूशन के पास कुछ बसेस होंगे, कुछ
Sir.
गाड़ियां होंगी, कोई लैंड होगा, कोई बिल्डिंग होगी. तो
Sir.
अगर वो लोग पैसा नहीं दे रहे हैं आपको, if they are not paying you on a timely basis, even after getting, even if you have gotten an award, then what the court would do, वो उसका एक कोई प्रॉपर्टी अटैच कर लेगी, वो उसको बेच देगी, आपको जितना पैसा मिलता है वो आपको देगी और वापस उसको कर देगी.
Sir, that is a government organization. That is school and mass education के अंडर में आता है. सर्व शिक्षा अभियान. Oh, actually,
Okay.
that is a government organization.
Sir, even if it is a government organization, the law is same that you have to go into enforcement. You can try going to the Odisha High Court in writ petition because it is a government वो body. But
Right.
then I am not very much वो मतलब कि I'll not advise you this because it is on a very dicey ground. The Odisha High Court may entertain it, may not entertain it because the apt proceedings are enforcement proceedings. Now you can circumvent the law and you can, in writ jurisdiction, go to the High Court, say that okay, this is the government body, and I do not want to follow the same procedure as I have to follow for any corporate body. So you just direct the government to pay my amount. The High Court may entertain it, may not entertain it. I am not much very sure, but the appropriate proceedings are enforcement proceedings that will lie in the Odisha court where the institution is located. Yes. Second question, Sweta.
Yeah, yeah. Thank you. Karthik, please unmute Murli, Mr. Murli.
Yeah, good afternoon, sir. Are you able to hear?
Yeah, I'm able
Yes.
to hear. I'm able to hear you. Yes.
Sir, actually, I got a delayed payment in 2018 invoice, which I raised in that
Okay.
financial year. Now I found that it was amount paid by the no my customer is delayed. Now I can go for interest for the delayed
Sorry,
payment.
I did not get your question completely. You are saying that for principal amount you have already
No, no,
gone
sir.
to arbitration.
It is the financial year of 2018 invoice. I got delayed payment. Now I can go for claim for interest purpose.
So if you have gotten an award of delayed payment from MSME, then the MSME must have given you the interest also. It cannot only give you principal, because if you have an award from MSME itself, do you have an award from MSME itself?
Yes, sir.
And you went to MSAFC for delayed payment, right?
We are not gone. That is we are not gone.
So you have to go to MSEFC first, and while
Okay.
you go to MSEFC first for your delayed payment, the MSEFC would, while awarding you the delayed payment amount, the principal amount, would have to give you the delayed interest also. If it is proved that you have an amount of, let's say, 5 lakh of rupees, you demand 5 lakh of rupees from the opposite party, and there is delay of 2 years, then there is no reason as to why the MSEFC would not give you 2 years of interest, because it is mandated in law.
Okay. Okay.
Thank you so much, sir. Karthik, please unmute Vivekanand, sir.
Hello.
Hello, hi
Can you
Vivekanand
hear
sir.
us? Yeah.
Hello.
Hello, yes sir.
Are you able to hear me?
Yes, I can hear you fine, sir.
When MSMEFC does not follow the act and rules and delaying to issue the award, where we have to approach?
You have to approach High Court of that respective jurisdiction. If the MSEFC of, let's say, is of Delhi, then you should approach Delhi High Court.
Ah, okay. Okay.
You have to approach the
Okay,
High
sir.
Court
Okay.
in writ jurisdiction, asking the High Court to interfere and direct the MSEFC to decide the dispute in 90 days, which is mandated in the statute. Is there any more questions, Shweta? Yeah, sure.
Thank you so much, everyone, for your patience and being with us in this webinar. But due to some technical glitch, प्रतीक सर का कुछ प्रॉब्लम हो गया है, तो वो अब हमारे साथ बन नहीं पाएंगे. तो जिनकी भी क्वेरीज और जिनके क्वेश्चंस मिस आउट हो गए हैं और रह गए हैं, तो आवर टीम विल कॉन्टैक्ट देम एंड उनकी जो क्वेरीज है वो हम रिजॉल्व करने की पूरी कोशिश करेंगे. थैंक यू सो मच फॉर बीइंग विद अस. Thank you so much. So we are ending this session. Thank you.